My name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and the perception of encryption in courts. So I've talked for a long time about encryption and why it's very important that people who are in authority, who are either making precedents in cases or passing legislation, that they understand encryption and they understand either rulings that they're doing regarding encryption or laws that they're trying to create around encryption, whether that be to weaken it or whatever. There is a recent court case going on in the U.S., very interesting. This started actually before the election and it's related to COVID. So in the state of Michigan, there were some people who were planning to kidnap the governor of Michigan because she put a mask mandate in Michigan. And this plot was thwarted by the FBI, so they did not kidnap and harm the governor. But the people who did this are on trial for conspiracy to actually do this act. So one of the charges that was put to these people, two people in particular, were threatening an act of terrorism. So the state of Michigan has a law that says that you can be charged with an act of terrorism if you're conspiring to do something possibly against the government or something like that. So this particular charge against two men in Michigan was dropped, even though they had other charges. So this particular charge was dropped about the threatening of act of terrorism, and the judge in the case, this is a 12th district court case, said that the reason why, I have to read this because I couldn't believe it. Okay, so the state judge recently ruled that two men who plotted to kidnap Michigan's governor did not make terroristic threats because they used an encrypted chat app to do so, and the judge considered that to be like a private thought. So these two guys used a Wire, which is an encrypted chat app, to try to plan out this kidnapping. And it was very shocking to me when I read this particular thing, and especially the description of what this judge thought encryption was, which is frightening. So encryption is not telepathy, first of all, and let's take it separately. So first of all, a chat app, whether it's encrypted or not, is made for chatting. So it is not like a diary. It's not like a journal. The purpose of it is to communicate with someone else. So you address a message to someone, you send it, and in my opinion, that's no longer a private thought because you're communicating with another person. It's no different than sending a text message or even picking up the phone and talking to someone. So encryption is a way to secure communications, whether it's in transit or at rest. So it's not magical. It really is, very simple in terms of the concept. So if you think about banking, when you're banking on your phone, you are sending information and receiving information in a secure fashion so that other people can't get to that information. But in this particular case, especially when you're charged with something like a federal crime or a crime against someone and terror, a lot of those privacy protections are not the same. So the government does have the information that was communicated between these two people, but I think it remains to be seen how, whether this particular case will be used as a precedent in the future or how other cases will be decided in terms of trying to explain what encryption is and how encryption works. So it remains to be seen if this will, how it will work on appeal, if other courts will take the same view. But I think it's very important that if we're using technology, it's important to understand how the technology works so that you have a proper perspective when decisions are made or when regulations are being enacted. That's it. Thank you.